Every crime is a wound on the world. We're here to dissect it, layer by layer, to find the truth buried within. This is Anatomy of Crime. The air in Waukesha, Wisconsin on November 21, 2021 was cold, but the atmosphere was one of pure, uncomplicated warmth. It was the 58th annual Christmas parade, a cherished tradition in this city of 70,000, nestled west of Milwaukee. This parade was special. It was a return to normalcy, a communal exhale after the long, isolating months of the pandemic. Streets were lined with families bundled in coats and hats, sipping hot chocolate. Children sat on curbs, their faces turned upward, waiting for the first glimpse of the marching bands, the festive floats, and the local heroes. The theme was comfort and joy. You could hear the music first. The high school bands, the sound of drums and horns echoing off the brick facades of Main Street, and then you would see them. The dance troupes, the local businesses with decorated trucks, and of course, the Milwaukee dancing grannies, a beloved fixture. These women, grandmothers and great-grandmothers, practiced all year for this. They moved with a joy and spirit that belied their ages, their pom-poms flashing, their smiles a beacon of community pride. It was the very picture of Heartland America. And then, into this scene of profound innocence came the antithesis, a red Ford Escape appearing suddenly. Moving far too fast, it breached the barricades, ignoring the frantic waves of a police officer. At first, there was confusion. Was this part of the show, a late entry? The confusion lasted only a second. The vehicle didn't slow down, it accelerated. The first screams were not of joy but of terror. The red SUV swerved, a deliberate zigzagging motion, striking bodies with a sickening, repetitive thud. It plowed through the Catholic community float. It struck the Waukesha Extreme Dance Team, a group of girls aged 9 to 15, and then it tore directly through the ranks of the dancing grannies. The music stopped. The air, moments before filled with carols and laughter, was now filled with the sounds of chaos, of pain, and of disbelief. The vehicle continued undeterred for 5 city blocks, a crimson scar of devastation. It left behind a scene that first responders would later describe as a war zone. When it was over, 6 people were dead. More than 60 others were injured. Their lives, and the life of their city, fractured in an instant. The man behind the wheel was Darrell Brooks, and while his act of mass murder was horrific, it was what came next that would define this case. The crime was an explosion of violence. The trial would be a slow, agonizing dissection of obstinance, delusion, and the limits of the American legal system. Today on Anatomy of Crime, we are not just examining the what of that day. The what is agonizingly clear. We are dissecting the anatomy of a trial where the perpetrator chose to represent himself, not with a coherent legal strategy, but with a bizarre, pseudo-legal script drawn from the fringes of anti-government ideology. This is the anatomy of a courtroom shipwreck, a story of mass murder and the sovereign citizen movement. To understand the trial, you must first understand the man at its center. Darrell Brooks Jr. was 40 years old at the time of the attack. His life was not a single tragic turn. It was a long, consistent pattern of instability, violence, and a profound refusal to accept the consequences of his actions. His criminal record was a roadmap of this pathology, stretching back to 1999. It was thick with charges in multiple states: battery, domestic abuse, resisting arrest, firearm possession, drug charges, and statutory rape. He was a man who moved through life leaving a wake of trauma, particularly for the women in his life. He had a documented history of domestic violence. In 2020, he had been charged with recklessly endangering safety after allegedly firing a gun at his nephew during a fight. Just weeks before the parade, on November 2, 2021, he was arrested again. This time, the allegations were that he had run over the mother of his child with the same red Ford Escape in a Milwaukee gas station parking lot. He was charged with 5 felonies for that incident, including second-degree reckless endangerment. He was released from custody on November 11th, just 10 days before the parade, on a cash bail of $1,000. This bail amount, set by the Milwaukee County District Attorney's Office, would later be described by that same office as inappropriately low. It was a catastrophic misjudgment, one that would leave an indelible mark on the community of Waukesha. On the day of the parade, November 21st, Brooks was once again involved in a domestic disturbance. Police were called to a location near the parade route. The caller was Erica Patterson, the same woman he had allegedly run over weeks earlier. She told the 911 dispatcher that Brooks had just been at her location, had argued with her, and had punched her in the face. She was on the phone with the dispatcher when the first reports of the parade incident began flooding the 911 system. Brooks had fled the scene of that domestic dispute, climbed into his red SUV, and driven directly toward the parade. The parade was already in full swing. The first officer to encounter him was Officer Bryce Boutron. Boutron was at a barricade when he saw the red Escape approach. He stepped in front of it, held up his hand, and yelled for Brooks to stop. Brooks slowed, maneuvered around the officer, and accelerated into the parade route. Another officer, Detective Casey, farther down the route, also tried to intervene. He pounded on the hood of the SUV. Brooks drove past him. What happened next was not an accident. It was not a panicked driver losing control. Multiple videos, from cell phones and city cameras, captured the horrifying totality of the event. Brooks was not merely speeding through the route. He was actively hunting within it. Witnesses described the vehicle zigzagging, swerving to hit clusters of people. The driver's window was down. His face was visible. He was not looking back as if being chased. He was looking forward, his gaze fixed on the path of destruction he was carving. He first struck the Waukesha South High School Blackshirt Band. Then he plowed into the Catholic community group. Then the Waukesha Extreme Dance Team. The impacts were brutal. Children and adults were thrown into the air, run over, and left behind as the SUV continued its rampage. And then he reached the dancing grannies. Virginia Ginny Sorensen, 79. Leanna Owen, 71. Tamara Durand, 52. Wilhelm Bill Hospal, 81, who was helping the group. They, along with 52-year-old Jane Kulick, who was marching with a Citizens Bank float, and 8-year-old Jackson Sparks, who was marching with his baseball team, would all die from the injuries they sustained that day. Jackson passed away 2 days later, his brother Tucker also severely injured but surviving. The SUV finally burst through the last barricade and sped away, leaving a tableau of absolute horror. 62 people were injured, many of them critically, with life-altering wounds, traumatic brain injuries, shattered bones, and the invisible, deep-seated trauma of surviving such an attack. Brooks did not get far. He ditched the damaged SUV and began walking through a nearby neighborhood. He was cold, without a jacket. He approached a home, knocking on the door. The resident, Daniel Ryder, let him in. Believing Brooks was homeless and needed to use the phone, Brooks was calm. He asked for a sandwich and a jacket. He called his mother. Ryder, unaware of what had just unfolded blocks away, tried to help him. It was only when police, tracking Brooks, arrived at Ryder's door that the encounter ended. Brooks was arrested peacefully on a stranger's porch just 20 minutes after committing one of the worst mass casualty events in Wisconsin history. The immediate aftermath was a blur of grief and investigation. The evidence was, to put it mildly, overwhelming. There were hundreds of eyewitnesses. There was high-definition video from multiple angles. There was the SUV with its damage and DNA evidence. There was his own flight from the scene. The what and the who were never in doubt. The case seemed destined to be a somber, straightforward, and tragic legal proceeding. Initially, that's how it appeared. Brooks was charged with 6 counts of first-degree intentional homicide, 61 counts of recklessly endangering safety, and numerous other charges. His defense attorneys entered a plea of not guilty by reason of mental disease or defect, an insanity plea. This signaled a legal battle focused on psychology, on Brooks's state of mind, on his capacity to understand his actions. But then, everything changed. In September 2022, just weeks before the trial was set to begin, Brooks suddenly withdrew his insanity plea, and then he made a decision that would transform the proceedings from a tragedy into a circus. He fired his public defenders and filed a motion to represent himself. This is the hinge point of the case. This is where the unique anatomy of the Waukesha tragedy begins to truly reveal itself. The right for a defendant to act as their own lawyer, known as pro se representation, is a fundamental right in the American legal system, affirmed by the Supreme Court in the 1975 case Ferretta v. California. But this right comes with a massive caveat. A judge must determine if the defendant is knowingly, intelligently, and voluntarily waiving their right to counsel. They don't have to be a good lawyer. They don't have to be smart. They just have to be competent enough to understand the monumental risk they are taking. The task of navigating this legal minefield fell to Waukesha County Circuit Court Judge Jennifer Dorough. From the very beginning, she was placed in an impossible position. She had to protect Brooks's constitutional right to represent himself, while simultaneously ensuring a fair and orderly trial for the prosecution, the victims, and the community. Brooks, it would soon become clear, was not interested in a fair trial. He was interested in a performance. Judge Dorough engaged in a lengthy, painstaking colloquy with Brooks, warning him repeatedly of the dangers. She told him he would be at a severe disadvantage. He would be expected to follow the same complex rules of evidence and procedure as a trained attorney. He would be facing a team of experienced prosecutors. He confirmed he understood. He insisted. Reluctantly, Judge Dorough granted his request. The trial, set for October 2022, would proceed with Darrell Brooks, the alleged mass murderer, acting as his own attorney. And it was here that the world was introduced to the bizarre, nonsensical, and deeply corrosive ideology of the sovereign citizen movement. To understand the trial, one must first understand this movement. Sovereign citizens are a loosely connected group of anti-government extremists. They adhere to a complex, pseudo-legal conspiracy theory. At its core, they believe that the United States government, as we know it, is an illegitimate corporation. They believe that when a person is born, the government creates a secret trust account, a straw man, tied to their birth certificate, which is then used as collateral to trade on the international market. According to this ideology, the real flesh-and-blood person is the sovereign, and is not subject to any of the government's laws, taxes, or courts. The straw man, often denoted by writing a name in all capital letters, is the legal fiction they believe the court is attempting to prosecute. Their entire legal strategy, therefore, is not to argue the facts of the case, but to challenge the court's very authority to hear the case. They believe that by using specific, magical-sounding phrases and refusing to identify themselves by their corporate name, they can break the court's power. They will refuse to answer to their name, saying, "I am the beneficiary of that trust," or "I am the agent for the client, Darrell Brooks." They will challenge subject matter jurisdiction. They will claim the court is operating under admiralty law, a maritime law, pointing to the gold-fringed flag in the courtroom as proof. They will ask the plaintiff, in this case, the state of Wisconsin, to produce a body or produce the original claim. It is a legal strategy designed to fail. It has never, not once, worked in a U.S. court. Its only practical effects are to clog the legal system, frustrate judges, and, in a case like this, re-traumatize victims. For a man like Darrell Brooks, a man with a lifelong pattern of narcissistic rage and a refusal to accept accountability, this ideology was not a legal strategy. It was a psychological shield. It was the perfect tool for his final desperate act of control. The trial began on October 3, 2022. It descended into chaos almost immediately. During jury selection, Brooks refused to answer to the name Darrell Brooks. He repeatedly interrupted Judge Dorough, demanding to know the nature and cause of the charges, and claiming he was not a person, but a sovereign citizen. He would declare, "I am here as an agent for the client." When Judge Dorough asked him to confirm his name for the record, he would reply, "I cannot answer that question. I am not a person." He would ask the judge for her oath of office. He would claim the state of Wisconsin, the plaintiff, was a corporation and had no standing to bring charges against him. Judge Dorough, displaying a level of patience that would become legendary, warned him repeatedly. His right to self-representation, she explained, was not a license to disrupt the proceedings. When his interruptions became incessant, she would have him removed from the main courtroom and placed in an adjacent glass-walled room, where he could observe the trial and speak via a microphone that she controlled. This became the rhythm of the trial. Brooks, in his orange jumpsuit, would appear on a monitor, muted. He would shout, gesture wildly, and hold papers up to the glass. Judge Dorough would unmute him to allow him to make his objections, which were invariably objection grounds or objection subject matter jurisdiction. When she asked him to provide a legal basis, he could not. He would simply repeat the sovereign citizen script. It was a staggering display of cognitive dissonance. Brooks had filed dozens of nonsensical handwritten motions, citing maritime law and the Uniform Commercial Code. He demanded the judge dismiss the case for failure to state a claim. He tried to bill the court for his time as a sovereign. All of it was methodically and patiently struck down by Judge Dorough, who created a meticulous record of every single outburst and every single ruling, protecting the case from any future appeal. The prosecution, led by District Attorney Sue Opper, began its case. It was a methodical, heartbreaking, and overwhelming presentation of the facts. They called 60 witnesses. They showed the videos. They played the 911 calls. They brought in the first responders who described the war zone. And then came the victims. Survivors of the attack, still bearing the physical and mental scars, had to take the stand, and they had to be cross-examined by the man who had run them down. This was the true anatomy of the trial's cruelty. Brooks's cross-examinations were a masterclass in narcissistic injury and deliberate torment. He was not trying to find inconsistencies in their testimony. He was trying to assert his dominance. He would ask a witness who had just described being hit by the red SUV, "Did you see me driving that vehicle?" When they said they saw the vehicle, but not his face, he would act as if this was a major victory. He asked one police officer, "Did you take an oath to the Constitution? Are you aware that the state of Wisconsin is a corporation?" He asked another witness if they swore an oath to God. He would ramble, misread documents, and become enraged when the prosecution objected to his nonsensical or improper questions. His antics grew more bizarre. At one point, during the testimony of a detective, Brooks constructed a fort out of the empty cardboard boxes his files had come in. Hiding his face from the witness and the jury, he would peek out from behind it, a grotesque game of peekaboo in the middle of a mass murder trial. Judge Doro ordered him to take it down. He would stare menacingly at witnesses. He would mutter under his breath. He would take off his shirt in the auxiliary courtroom. He would have loud, emotional outbursts, claiming he was the one being disrespected. "This is not a search for the truth," he would yell. "This is a political game." He was removed from the courtroom over a dozen times, his disruptions so severe that Judge Doro eventually had to revoke his self-representation rights, but only for brief portions of the trial, before restoring them. The emotional toll was immense. Witnesses broke down on the stand, not just from recounting the horror of the parade, but from the indignity of being questioned by their attacker. Brooks seemed to relish it. He was, for the last time in his life, the center of attention. He was in control. He was hurting people. And the rules of the court, which he so openly despised, were ironically the very things giving him the power to do it. When it was time for the defense to present its case, Brooks had nothing. His entire strategy had been to prove the court was illegitimate. It had failed. He called only one witness, his ex-girlfriend, Erica Patterson, the woman he had allegedly punched just before the parade. It backfired spectacularly. Under his own clumsy questioning, she testified about their argument, placing him at the scene agitated, just moments before the attack. He had, in effect, helped the prosecution establish his motive for fleeing. He had intended to call his mother, but after a contentious, tearful argument with her over the phone from jail, which was played in court, she refused to testify for him. He had no other witnesses. His case was closed. The closing arguments were a stark contrast. The prosecution delivered a calm, 2-hour summation, walking the jury through the mountain of evidence, video by video, victim by victim, charge by charge. They highlighted the zigzag pattern, the acceleration, the lack of any attempt to stop. This was not flight, they argued. This was intentional. This was murder. Then it was Brooks's turn. He spoke for an hour. It was a rambling, incoherent, and self-pitying speech. He cried. He spoke about his children, his faith in God, and the lies told about him. He barely mentioned the victims. He claimed he had been dehumanized. He seemed to suggest the car had malfunctioned, a theory for which he had presented zero evidence. He concluded by saying, "What you saw is not me. That is not who I am." The jury was not convinced. They deliberated for less than 3 hours. On October 26, 2022, they returned their verdict, guilty, on all 76 counts, 6 counts of first-degree intentional homicide with intent, 61 counts of reckless endangerment, and all the associated charges. For each guilty count, Brooks, sitting in the auxiliary courtroom, stared blankly at the screen. The sovereign citizen's magic words had failed. Reality had delivered its final devastating judgment. The sentencing hearing began on November 15, 2022. It was not a legal proceeding. It was a 2-day exorcism of a community's pain. Dozens of victims and their families gave impact statements. They spoke not to Brooks, but at him. They described their lost loved ones, the grandmothers who were the heartbeat of their families, the little boy who loved baseball, the community members who were simply there to spread joy. They described their own shattered lives, the survivors' guilt, the chronic pain, the terror that still grips them. They spoke with a raw, unfiltered fury and a profound, heartbreaking sadness. One by one they told Brooks they would not be defined by his evil. They told him they were a community and they would heal. When it was his turn, Brooks spoke for over 2 hours. It was a mirror of his trial performance. A winding, confusing monologue filled with excuses, self-pity, and references to God. He blamed the media. He blamed the prosecution. He blamed his upbringing. He offered half apologies, saying he was sorry for what happened, but never, "I am sorry for what I did." He continued to hint at forces beyond his control, never once taking full, unambiguous responsibility. Finally, it was Judge Doro's turn, and after weeks of enduring his disruptions with almost superhuman restraint, she delivered a masterwork of judicial condemnation. She spoke for over an hour, methodically and powerfully. She addressed the victims, honoring their pain and their strength. And then she addressed Brooks. She dismantled his entire sovereign citizen defense, calling it nonsensical and an affront to the rule of law. She addressed his claims of being dehumanized, stating, "Frankly, Mr. Brooks, no one is safe from you." She painstakingly walked through the aggravating factors of the crime: the number of victims, the targeting of children and the elderly, the sheer callousness and brutality of his actions. And she addressed his character. She noted his complete lack of remorse, his stunning lack of empathy, and his narcissistic personality. She said, "There is no medication or treatment for a heart that is bent on evil. Some people, unfortunately, choose a path of evil, and I think, Mr. Brooks, you are one of those such persons." For each of the 6 counts of first-degree intentional homicide, she sentenced him to life in prison, without the possibility of parole. She ordered these sentences to be served consecutively, one after the other. Then she added the sentences for the other 70 charges, 763 additional years. It was a sentence meant not just for punishment, but for a message that his life as a free man was over 6 times over. So what is the anatomy of the Waukesha parade tragedy? It is not a whodunit. We knew who did it within minutes. It is barely a whydunit. The why is a depressingly familiar cocktail of domestic violence, narcissistic rage, and a desperate cowardly flight from accountability. The true, unique anatomy of this case is the collision of 2 opposing forces. It is the story of a community's sacred space, a parade of comfort and joy, being violated by an act of profound nihilism. And it is the story of a legal system, built on order and reason, being forced to give a platform to an ideology built on chaos and delusion. The trial of Darrell Brooks was not a search for the truth. The truth was obvious from the first horrifying video. The trial was a test of the system's own integrity. It was a grueling endurance match between the patience of the court and the petulance of a killer. Darrell Brooks's sovereign citizen defense was his final pathetic weapon. When he could no longer control his victims with a Twatten vehicle, he tried to control the courtroom with a barrage of nonsensical paper and shouted objections. It was the last act of a man who believed that if he simply refused to acknowledge reality, the barricades, the police, the law, his own name, then reality and its consequences could not touch him. In the end, the spectacle faded. The nonsensical objections and claims of joinder evaporated into the air of the silent courtroom. What remained were the 6 consecutive life sentences and the indelible memory of those who had gathered for a parade, only to be met by a fury that had no jurisdiction and a void that no argument, real or imagined, could ever hope to fill. This has been Anatomy of Crime, where the truth is never simple, but always worth seeking.